Hello everyone, welcome to my channel. Before watching this video, don't forget to like, comment and subscribe. Now let's start this video. Components of Maritime Law Part 2. When a ship strands or collides with another vessel, substantial cargo loss or damage might result. If the casualty is found to have been caused by a sea peril or an error in navigation, there will be no liability if the goods are being carried under a statutory of contractual provision based upon the Brussels Convention of Limitation of Liability at 1923, which incorporated the so which incorporated the so-called Hague rules. If, however, the casualty was the result of the carrier's failure to exercise due diligence to make the ship seaworthy and to see that it was properly manned, equipped, and supplied, the carrier will be held responsible. Limitation of liability. A distinctive feature of maritime law is the privilege accorded to a ship owner and certain other persons, such as charterers in some instances, to limit the amount of their liability under certain circumstances in respect of tort and some contract claims. In some countries, including the United States, the limit, except as to claims for personal injury and wrongful death, is the value of the ship and the earnings of voyage on which it was engaged at the time of the casualty. On the other hand, in the United Kingdom and the other countries that have ratified the Brussels Limitation of Liability Conventions of 1957 or enacted domestic legislation embracing its terms, the limit is 28 pounds sterling or its equivalent by the adjusted net tonnage of the vessel regardless of its actual value. The basic condition of the privilege is that the party asserting it must be free from privity or knowledge, in the words of United States statute, or actual fault or privity in the words of the convention. This formula means, generally speaking, that the ship owner is entitled to limit his liability for the negligence of the master or crew, but not for his own personal negligence or that of his managerial personnel. In a sense of limited liability of ship owners may be compared to the limited liability that any investor may now achieve by incorporating his enterprise. The limited liability idea in maritime law, however, long antedates the emergence or invention of the modern corporation or limited company. Its early appearance in maritime law may be taken as a recognition of the extraordinary hazard of seaborne commerce and the need to protect the adventurous ship owner from the crushing burden of liability that is, in the days before even the most primitive forms of insurance had become available. Some modern commentators have suggested that the peculiar features of maritime limitation of liability have outlived their usefulness and that the development of insurance and the modern limited liability company has radically altered the condition out of which the ship owner's privilege originally grew. Although no maritime country has not gone to the length of abolishing limitation of liability, ship-owning interests appear to have become concerned about the possibility of such a development. In most maritime countries, the principle of limitation of liability was considered to be a part of the general maritime law. As it developed in the continental Europe, the idea generally stated was that a ship owner entitled to a limitation could satisfy his liability by abandoning the ship and its pending freight to claimants. Since the privilege of limitation was and is typically invoked following a large-scale maritime disaster, the abandonment theory meant that claimants got the value of the ship as it was following the disaster. If the ship have if the ship had sunk or was a total loss with no freight pending, the claimants got nothing. This theory was carried over into the law of many South American countries. Great Britain and the United States were once the only maritime countries that refused to admit the principle of limitation as part of the general maritime law. In both countries, however, the competitive needs of the shipping industry compelled its introduction by statute. In general, the limitation of law any country will be applied by its own courts in favor of foreign ship owners as well as of citizens. From the point of view of ship-owning interests, however, a major weakness of limitation has been the fact that limitation proceedings were not given international recognition. That has meant that a ship owner whose ship moved in international trade could find himself sued in several countries as a result of one disaster and forced to set up limitation funds in each country. The Brussels Convention of 1970 The Brussels Convention of 1957 makes limitation decrees delivered by admiralty courts in ratifying countries internationally effective, that is, a ship owner is required to set up only one limitation fund, out of which all claims are paid, no matter in how many countries proceeding might be instituted against him. Thus, the convention, which increases the liability of ship owners in most countries, does offer in return this considerable advantage to ship owners. Collision liability. Under maritime law, responsibility for collision damage is based upon the fault principle. A colliding vessel will not be held responsible for damage to another ship or to a fixed object such as a bridge, wharf, or jetty unless the collision is caused by a deficiency in the colliding vessel or by negligence or a willful act on the part of its navigators. It is not always necessary, however, to establish fault by positive evidence. There is a presumption of fault when a moving vessel collides with a fixed object or with another vessel that is properly moored or anchored, and the burden of proving freedom from fault will lie with the moving vessel. In countries that have adopted the International Convention for Unification of Certain Rules relating to collision between vessels, signed at Brussels in 1910, the rule of comparative negligence governs. If each of two colliding vessels is to blame, the total damage will be divided between their owners or operators in proportion to the respective degrees of fault. In certain countries that have not ratified the convention, such as the United States, the law is such as if both vessels are to blame, the total damage are equally divided, regardless of the respective degrees of fault. In certain other countries that have not ratified the convention, including most of the Latin American states, the principle of contributory fault governs. If both vessels are to blame, each owner or operator bears his own damage. Salvage and general average. Salvage and general average are doctrines peculiar to maritime law. Under the law of salvage, stranger to the maritime venture who succeed in saving maritime property from loss or damage from perils of the sea or other waters are entitled to an award for their effort and have a maritime lien on salvage property therefore. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one. Bye bye.